Conditions, like any contractual term, can be express or implied. Express conditions are those that are written by the parties within the four corners of the contract. They're actual agreement. Express conditions must be strictly, completely, totally performed. Any non-compliance is not only a breach, but it also means that whatever promise on the other side will not come due until that condition is completely performed. What do conditions do? Well, it depends on their nature. There are really two ways that conditions operate. They can either create a duty where it did not exist before or extinguish one. Most common are conditions precedent, which create a duty. There are also conditions subsequent, which terminate a duty. Initially, the failure of a condition to occur means the other party has the right to withhold performance, for a reasonable time at least. After a reasonable time, the party's duty to perform is extinguished or discharged. So there is this concept of a cure period after the condition was not performed, where it could still become performed, but until then the party can withhold. In Morrison, we saw an example of an express condition, the non-occurrence of which discharged the other party's duty to perform. The condition was that the seller would fix a heat exchanger. The heat exchanger was not fixed, and the buyer wanted to force the seller to sell the house for a lower price. This was not an option. Failing to fix the heat exchanger was not a breach. It was simply a failure to create a condition, such that the buyer had the right not to purchase the house. The buyer's duty to purchase the house was extinguished. He could have waived that and bought the house regardless of not having a duty, or formed a new contract, or renegotiated, but cannot sue for the failure of a condition to come about. Generally, the non-occurrence of a condition is not a breach, as we saw in Morrison. However, in International Rotterdam, we saw a promissory condition, the unusual case where a condition is also a promise. The non-occurrence of such a promissory condition is a breach. Since any defect in the occurrence of a condition, no matter how trivial, absolves the other party's duty to perform completely, this can lead to harsh results, including forfeiture. The courts thus interpret conditions as to avoid forfeiture. We saw in the case of Peacock Construction how courts will attempt to avoid forfeiture by interpreting covenants not to be express conditions where they're reasonably susceptible to such a meaning. Peacock Construction illustrate how courts will prefer to interpret terms or promises where their interpretation should be, should prefer to interpret terms as promises where interpreting them as express conditions will create a forfeiture. In this case, we had a contractor who was not to be paid, at least according to the terms. The subcontractor was not to be paid until the general contractor was paid. But it was a huge project, like a skyscraper, and this was a small guy on the job. Didn't really make sense that he would hold that risk, and so the court found this was more of a promise, setting out the designated scope of when payment should be expected, and not a condition to the payment of the subcontractor. So they interpreted that contract to avoid forfeiture. There's one type of condition which is particularly difficult. This is usually an express condition which creates some challenge, when the condition is a condition of satisfaction of the obligor. There are two special rules, so the obligor cannot take advantage of this situation. First, courts prefer to use an objective standard, asking whether a reasonable person in the obligor's position should reasonably be satisfied. Second, when a subjective standard is needed, it is bound by the duty of good faith and requires honesty in fact. You can't pretend you're not satisfied when you really are, even under the subjective standard. We have a couple illustrations. In Hutton versus Monogram Plus, someone was not satisfied with the financing terms, but had not shopped around enough to get better terms. And the court found it was not reasonable for them to be dissatisfied under those circumstances. And in Morin Building versus Baystone Construction, we saw this in an even bigger way. The contract was very express that the architect had sole discretion and authority, to determine whether or not this aluminum siding was attractive enough. But the court, I think, rightly found that despite the express terms, they were going to apply an objective standard to how a reasonable architect would find the siding on the outside of a warehouse, given that it was not an aesthetic object. And that does lead us to a little bit of an understanding as to when courts will apply the objective and subjective standard and what the result of that application is. An objective standard will apply generally to things that are commercial or have a commercial quality or value, looking for operative fitness, not necessarily that the pellets of iron are pretty, but that they're the right size and dimension and content for the task. The subjective standard will be reserved for matters of fancy, personal taste, aesthetics, when it's expressly called for in the contract. In the case of an objective standard, we ask, would a reasonable person in the position of the obligor be satisfied? Whereas in a subjective approach, we ask whether or not this person was actually satisfied, although they need to be acting in good faith and not to take deliberate advantage of a contract counterparty. And since conditions can have harsh results, courts might find that they are waived. The waiver of conditions came up in J&A Realty Corp. As J&A illustrates, courts sometimes find waiver as a matter of fact, meaning the party. So waiver is different than excuse because waiver is something that the counterparty can do. Excuse is something courts do. And so if the lessor, in this case, the person who is renting out the building to the lessee, there was a condition that the lessee give notice within 6 months of intention to renew, the lessor can waive that condition. And in J&A Realty, the court found, as a matter of fact, that that condition was waived. In part, they did this in order to avoid the forfeiture that might result if the resident, the lessee, had to abandon their restaurant in that location. So as J&A Realty illustrates, courts sometimes find waiver as a matter of fact, even though they may actually be employing the doctrine of excuse as a matter of law, which leads us to the doctrine of excuse. And we can see that in Restatement Section 229. The excuse doctrine permits a court to excuse the non-performance of a condition to avoid forfeiture. And we saw this as well in the case of Burger King versus Family Dining. In fact, that case had both excuse and waiver. Useful to reread to get your head around both those concepts. Burger King versus Family Dining illustrates how similar facts can give rise to both a waiver argument and for arguments for excuse of a condition. Again, this reminds us that express conditions may only be satisfied by complete performance. So courts may try to ameliorate the harshness of this rule by waiver or excuse. Substantial performance will not suffice in the case of an express condition.